now in session. Thank you. Please be seated. This is Court of Appeals, case number CR150202, State of Arizona versus Donald William Gully. Welcome. We are, for the party's information, we are recording these proceedings. So as you approach the bench, please, or the podium, please say your name and who you are representing. Hopefully, if it all works, you will have your 20 minutes of fame on YouTube. The appellant, you will have 20 minutes. You may reserve a portion of your time for rebuttal. And if you do that, just let us know before you start how much time you want to reserve. We'll try not to horn in on your time too much. We understand that the Attorney General's office and the amicus from Yavapai County have agreed to split up their time. And so please keep an eye on the podium. We're not going to do anything different when your time is up. You can sit down. With that in mind, we may begin.
Good morning. My name is Grace Geiswhite. I'm here today with counsel John Napper and Michelle DeWalshy on behalf of Donald Gully. As we speak, Mr. Gully sits in prison. He should not be there. He's there because his 2-day trial was fundamentally flawed in 5 different ways. First, it was fundamental error for Mr. Gully to have been convicted of a non-existent felony under Arizona Revised Statute 13-707B, 13-707 subsection B. Second, it was fundamental error for the jury, instead of the judge, to have found Mr. Gully's prior conviction. Third, there was insufficient evidence presented at trial to find that Mr. Gully had previously committed the same misdemeanor. Fourth, there was insufficient evidence presented after trial that Mr. Gully had 2 prior historical felony convictions. And finally, it was an abuse of discretion for the court to have admitted Stephen White's testimony under the excited utterance or present sense impression exceptions to hearsay. With regard to error number 1, it was fundamental error occurred when Mr. Gully was convicted of 2 Class 6 misdemeanors under Arizona Revised Statute 13-707 subsection B. That subsection B is the section that deals with enhancing punishment for prior misdemeanor convictions. Here, all parties proceeded wrongly. Mr. Gully was charged with Class 6 felonies, he was convicted of Class 6 felonies, and then he was sentenced as a Category 3 offender because the court applied Arizona Revised Statute 13-703. This was all wrong. Under the plain statutory text, Mr. Gully should have been charged with Class 1 misdemeanors. He should have been convicted then of Class 1 misdemeanors. The judge then should have determined if he had a prior same misdemeanor within 2 years, and if so, she then could have enhanced his sentence, which in this case would have been to the next category of offense, a Class 6 felony.
This is the first time in a long time that I've heard a defendant argue that only the court can determine sentence enhancers. I mean, is there an Apprendi problem with your argument?
Your Honor, under the Apprendi-Blakely line of cases, what the court said is that it was up to the states as to whether or not the courts or the jury should be finding prior convictions. Here, what Arizona has done since 1996 is held that for prior convictions, it is the judge who should be determining those prior convictions unless the prior conviction is an element of the crime, which in this case it was not.
But in this case, trial counsel argued that it was an element of the crime. So do we have an invited error problem?
The error in this case is that it was the wrong fact finder. That was not.
Well, but when the defendant argues affirmatively that the prior is an element of the offense, which I might be inclined to agree with you is wrong, don't we have invited error? Is this the case to fix that?
At no point did the defendant argue affirmatively that this was an element of the offense. Instead, what it appears as if occurred is that the proceedings below did not track any statute. They did not track any of the rules. They simply proceeded under the wrong misconception. And this occurred from the beginning. The state charged him with a felony, and then all parties proceeded wrongly from there.
But if he had been charged with, and this is more of a footnote, if he had been charged with a misdemeanor and then convicted of a crime that where he's to be sentenced as a felony, wouldn't we be here arguing that the conviction didn't match the charge? I mean, the legislature has made this a little tricky, a little difficult. I understand. There's nothing clear about it. But what is clear is that some individuals are eligible to be sentenced as felons even though they commit a crime that is nominally designated a misdemeanor in the first instance.
The statute on its face appears clear that you're correct. It's an enhanced punishment statute, and the courts have interpreted that way. It is, if he was convicted of a Class 1 misdemeanor because of prior conduct, he could then be sentenced to the next higher category of offense. And we know that the legislative branch in other statutes says guilty of instead of sentenced to the next higher offense when they want to. For example, the shoplifting statute says that if you commit a shoplifting and you have prior convictions, then you are guilty of a higher offense felony. That is not the language that was used here. It's simply an enhancement statute that allows for repeat misdemeanor conduct to be sentenced more harshly. But that doesn't change the underlying text of the statute that says it's to be convicted as a misdemeanor.
But Section 13-601 says felonies and misdemeanors are classified for the purpose of sentencing or the purpose of sentence. So if you're sentenced as a felon, that must mean that you committed a felony.
We disagree with that. This is just sentenced to the next higher class of offense. And the statutory text of 707B specifically outlines convicted of a misdemeanor, sentenced to the next higher class of offense, which in this case just happens to be a Class 6 felony.
But if the purpose of the classification between felony and misdemeanor is sentence, which is what the statute says, then when you impose a sentence that equates to a felony sentence, then that means you've committed a felony.
But we know from other statutes that it is simply not a matter of sentencing. There's other repercussions to be convicted of a misdemeanor instead of being convicted of a felony, including a drastic reduction in your rights, the right to vote, the right to hold public office. Just a couple examples, if you are convicted of a felony versus convicted of a misdemeanor. When we're only applying a sentencing range, then you are still allowing those people, those persons with misdemeanors to hold all of those rights, simply just making them spend some more time in jail for repeating their same conduct. We also believe that the face of the statute is clear, that what occurred was wrong. He should, and we agree with the Attorney General as to this matter, that the remedy for this is a new sentencing, that he should be remanded and that his Class 6 felonies should be changed to Class 1 misdemeanors. He should then be sentenced to the next higher class of offense, which would in fact be a Class 6 felony. The second fundamental error here was when the jury found Mr. Gawley's prior conviction under Arizona Revised Statute 13-707, subsection C, and that's the trial on the prior subsection. Now, here, we believe this was fundamental error, and this prejudiced Mr. Gawley's trial. On its face, the statute says that the judge, not the jury, is supposed to find the prior convictions. And because that was not followed here, what occurred was that the jury not only heard of the prior conviction, the jury heard of the exact offense prior conviction is what Mr. Gawley was currently on trial for. He was being tried for disorderly conduct, and the jury was told that he had previously committed within 2 years a prior disorderly conduct.
But he agreed to that. I mean, how are we in a position to do anything about that if he stipulated to it at trial?
He agreed to the certified conviction, but the error we believe that occurred in this case was that the wrong fact finder found that prior conviction. The prejudice stemmed from that certified conviction.
Even if it were not invited error, wouldn't it be harmless error? Because the judge or jury would have certainly found the prior. He stipulated to the certified copy of the prior. How could it be found otherwise?
The reason that it is prejudicial because the jury who was deciding at that time whether or not he had committed disorderly conduct heard of his prior bad act.
But that's the very prejudice he stipulated to. The question isn't whose mind is more suited to make this determination. The question is, you want the jury not to hear about the prior while he's being tried for the current offense, which I understand. I mean, it seems to me that the proper way to proceed here would be to try him on the current offense. If he's convicted, then deal with the enhancements later. But that didn't happen here, and it didn't happen because defendants stipulated to it. That is a significant bar to relief.
Again, we believe that with regard to the invited error doctrine, what occurred here is the actual error was the fact finder. And the prejudice was then what was in the...
But really, the prejudice wasn't the fact finder deciding whether he had a prior conviction. The prejudice, you're arguing, is that the jury heard about a prior conviction which was prejudicial on the merits of the current offense. And those are two different issues.
And he stipulated to the admission of the document that proved the prior.
We understand that that was stipulation. Again, though, because of the contents of that certified conviction, we believe that it prejudiced Mr. Gawley's his trial on the alleged offense of disorderly conduct. And the reason for that is twofold. First, we have State v. Burns, the recent Arizona Supreme Court case, which discusses the fact that, it discusses the fact that prior convictions should not be heard by the juries. And in that case, it was a severance case. They decided to severance out the misconduct. They should have severed out the misconduct with weapons from the trial at hand, which was first-degree murder. And what's notable about that decision is there the defendant was on trial for first-degree murder, and the prior that the jury heard about, I believe, was burglary. Here, Mr. Gawley was on trial for disorderly conduct, and the prior that they heard about was disorderly conduct. The other differences between State v. Burns and Mr. Gawley's case is that in State v. Burns, the jury received a sanitized affidavit. Here, they received a certified conviction that was not sanitized in any way. It actually listed out the punishment that he had previously received, which was a year of unsupervised probation, counseling, and a fine. This also implicates the concerns in State v. Koch, which indicated that the juries are not to consider punishment, and especially not to consider anything in terms of leniency. What the jury read here was that for a prior disorderly conduct conviction, Mr. Gawley had received merely some unsupervised probation. And so we have the twofold concerns in both State v. Burns and in State v. Koch because of the certified conviction that was entered in this case. The third issue at hand is that there was insufficient evidence that Mr. Gawley had previously been convicted of a same misdemeanor. This, again, falls under Arizona Revised Statute 13-707, subsection B. And the issue here is that Mr. Gawley was charged and convicted of disorderly conduct under subsection A1, the seriously disruptive behavior portion of that statute. The evidence that was presented at trial simply indicated that he had been convicted of a prior disorderly conduct. It did not denote which of the 6 subsections of disorderly conduct he had previously pled no contest to.
The implication of that argument, though, troubles me. I mean, there are 6 subsections, and so you're suggesting that as long as one is sufficiently creative, he could commit this crime 6 times without having an eligible prior, and only on the 7th would he run out of options. I have a tough time imagining that the legislature that passed that statute meant that.
Well, if we look at the text of the statute, they do not define same misdemeanor. So then if we were to look at what their intent was, we know that if they had meant to simply punish people for engaging in repeat misdemeanor conduct, any repeat misdemeanor conduct, then they could have very easily written that if you're convicted of a misdemeanor and you've previously been convicted of any misdemeanor, then you can be subject to an enhancement of the statute. That's not what they wrote.
Clearly didn't write that, but they didn't. They also didn't write that each subsection is a separate offense, ineligible to enhance the other. These are all convictions under the same statute of a crime with the same name. But I mean, one could certainly argue that for grammatical convenience, they broke up the many ways that one can commit disorderly conduct into a few different sections. In
State v. Farini, the Arizona Supreme Court recognized that reorganizing of the model penal code grouped a lot of offenses together. But that wasn't meant to simply say this is now automatically all the same offense. And here, even though disorderly conduct has a heading of disorderly conduct, if we look through the subsections require different elements. And one of the biggest examples of that is the fact that subsection 5 is actually the element of inaction. It's not doing something, whereas the other subsections have to do with actual action, doing something in order to violate the statute. These are markedly different conduct as you go through the subsection. And the statute makes sense if what the legislative branch was concerned with was punishing conduct. That is how it makes the most sense when interpreting their purpose behind the statute and the fact that they did not simply say previously convicted of any misdemeanor. The fourth issue was that there was insufficient evidence that Mr. Ghali had 2 historical felony convictions. After trial, the court looked through Mr. Ghali's history. It appears from the record there was really no true trial on the priors. However, they ultimately found that he had been previously convicted of 2 historical felony convictions. And this was wrong for 2 reasons. First, 2 of the offenses that they heard about were on their face committed on the same date. However, the court did not hold an evidentiary hearing as required by State v. Kelly to determine if those felonies were actually of the same occasion. We believe the proper remedy there is for this court to remand for that evidentiary hearing to be held. The second issue was that, and this was objected to, is that the other felony convictions were proved through a plea agreement. Now, this plea agreement did not contain a photograph. It did not contain a fingerprint. And so what we have is the problem with what the courts have said, especially in State v. Haas and State v. Lee. There needs to be documentary evidence, such as a certified pen pack is what we commonly see, or there needs to be an admission under oath. We don't have that. Or there needs to be something from the state showing that despite their earnest attempts, they were unable to locate any documentary evidence. We do not have that. Instead, what we have is just a simple piece of paper where the avowal actually says he has no more than 2. Does not actually say he has 2 prior convictions. And so we believe that those were both found in error. Finally, the 5th error in this trial was it was an abuse of discretion for the trial court to have admitted Stephen White's statements as either an excited utterance or a present sense impression. Now, the Attorney General agrees that these statements were not present sense impressions. However, where we diverge is on the issue of excited utterance. What we know here from the record is that Mr. White and his mother, who were the 2 witnesses to this event, had time, whichever was to be believed at the trial court level in terms of the testimony, they had somewhere between 5 and 30 minutes while in a bedroom to reflect on what had occurred, to discuss what had occurred. And then we know there was an intervening walk that Mr. White took down to his brother's house. He did not stop at a house nearby. He then rolled a cigarette before anything was then told to law enforcement. We believe that this implicates the fact that it just simply wasn't reliable. The exceptions are there because of reliability, and here what we have is too much intervening time and a period of reflection. I see that I have about 3 minutes. I would like to reserve that for rebuttal. Thank you.
Thank you.
Aisha, do you have the signature sheet?
Good morning, Your Honors. My name is Terry Christ, representing the state of Arizona, and as agreed with the county, I'll be taking 13 minutes, and the county will have 7. May it please the court. I would like to move, actually, to begin with the second issue, the question of whether the judge or the jury should have determined the prior misdemeanors. And as the court has already noted, I think one of the most important things to keep in mind here is we really aren't talking about, as a form of prejudice, whether the jury heard about the priors of the guilt phase. We think that is invited error. The fact that the jury heard about it is actually not a necessary consequence of allowing them.
Would you concede that it is error, though?
Yes, I would concede that it's an error. The statute is clear that the judge should have made the determination. But error alone isn't reversible. Especially on fundamental error review, we have to show that the error was fundamental and it led to actual prejudice. And that's a showing the defense has the burden to present. And here...
What better case is there for actual prejudice than you open up a criminal trial by talking about the defendant's prior conviction for the same offense? It's really kind of hard to imagine a purer form of prejudice.
Well, Your Honor, I think there are at least two broad reasons why this case isn't apt to consider that. One is sort of the categorical bar of invited error. If you had a case where there weren't invited error, that would be a better avenue to address this question.
Agreed, but if we set aside the invited nature of the error for a moment, which is a big if, wouldn't this be sort of classic fundamental error?
I think not, Your Honor. I think, for one, the jury was given instructions, both at the voir dire phase and at the guilt phase. We have a presumption that jurors follow their instructions. So not only on fundamental error does a defendant have the burden to show actual prejudice, but they also have to overcome that presumption. So a lot of what we're talking about here, I think, is whether we have confidence that the jurors could have followed their instruction. And if the jurors had followed their instruction, I think we wouldn't have fundamental error. Because even though the court should have made the determination, if the jury did so and it didn't lead to any prejudicial consequences in the trial, I don't think that would be reversible. So then really the question is, do we have any assurances that the jurors actually could have followed their instruction? And I think there are several things about this case that can give us that confidence. For one, the trial court actually screened the voir dire panel on this question. The judge instructs the voir dire that they can't consider the certified conviction for purposes of substantive guilt, and then actually asks whether there are anyone at the panel who couldn't follow that instruction.
I understand, but that puts you on a dangerous slippery slope, right? Because almost any error then could become harmless or at least not fundamental because we had a good voir dire and we had good jury instructions.
Well, certainly.
Should leave the room at some point, and as long as the jurors are following their instructions, we wouldn't review for much error if that were a principle we followed here.
Well, I think it is important, at least in the analysis, to consider whether the jurors followed their instructions. Certainly, if they hadn't, we'd have a greater case for error. Here, I would say that's one of the factors we could consider. Perhaps it's not alone sufficient to say that there's no prejudice, but again, it's the defense's burden to show fundamental error, and speculation cuts against them. So if we aren't sure whether there's error or not, on fundamental error review, we don't reverse. It's a question of showing that they have to make because they didn't make the objections below. And so one of the reasons that I think we can have confidence there wasn't prejudice is the fact that they were instructed. They were screened, in fact, at the voir dire, which doesn't happen with a lot of these other sorts of errors. And then at the end of trial, they were given the instruction again. I think another thing that contributes to our assurance here is the fact that the jury's actually returned an acquittal on one of the counts. So one of the charges in this case was aggravated assault. They acquit on that and then return an assault conviction as a lesser included offense. And what that tells me is they're not rubber stamping the state's case. They're not so overwhelmed by the prejudice of knowing this prior conviction, not they think the defendant is a bad person, he must have done anything the state said he did. They are carefully weighing the evidence. They apparently decided that the elements of aggravated assault were not met, and so they returned the acquittal on that. I think one of the other things to keep in mind here is we actually do presume routinely that the jury follows instructions regarding prior convictions in other contexts. So when you have an impeachment under Rule 609, we instruct the jury, follow this instruction, you should only consider it for impeachment, not for substantive guilt, and we usually assume they would do that. When you have the prior conviction as an element of the offense, take aggravated DUI, for example, where you have to have, I think it's 3 prior regular DUIs and then it becomes aggravated. We presume that the jury can follow the instruction to only consider that for purposes of whether you've met that prior element and not for substantive guilt. Really, the only difference between this case and that case is the prior here goes to a sentence enhancement rather than an element. And there's nothing about the distinction between an element and a sentence enhancement that would somehow render the jury incapable of following the instruction.
Well, but typically we consider elements during the guilt phase and sentencing enhancements after the guilt phase for good reason, right?
Yes, for good reason, but at the same time, we do think juries can follow these instructions. The courts have certainly not adopted a rule that there is a per se fundamental reversible error anytime a prior conviction is uttered in a courtroom. And I don't think this is one of the extreme cases that would merit reversal. Another thing that I think contributes to that is when you look at the character of the evidence here, the primary source of evidence against the defendant were eyewitness testimonies from Eunice and Stephen White as related through Michael. And the jury really had to believe these witnesses to return a conviction. Whether the defendant had a prior conviction or not does not really go into the analysis of whether they find these witnesses credible. So, again, I think we have some assurances that the jury were able to follow their instructions. And as for the Burns case, I don't think the Burns case is really on point with what we're talking about here. One of the reasons is Burns is not a fundamental error case, and so the standard of review is a little more deferential to the defense. They didn't have the same burdens that they have to prove here.
But Burns presumably objected to that prior evidence coming in.
Yes, Your Honor. Burns moved to sever is what happened, because that was a case where multiple counts, including a murder count, were charged at the same time as a weapons misconduct. And in order to prove the weapons misconduct, I think they had to show an underlying burglary. So the court said that there should have been severance there. But again, not only is it harmless error review, but the court actually found harmless error. The other thing about that is Burns does have some language about how we are unsettled or how we not always confident about following jury instructions. But I don't think that's meant to be used for the purpose that the defense assumes here. What Burns is really talking about is we have this question of whether we should have severance. And when you have severance, you have to go through a two-stage analysis. One is whether the counts could have been tried together, whether there's cross-admissibility. And then two, whether there's actual prejudice. So really, I think what Burns is saying is if two counts should be tried separately, you can't glue them together with a jury instruction. So just because you instructed the jury doesn't give you license to pair any two counts you want. But that's not really the harmless error analysis, because if the prejudice could not have been cured by a jury instruction, they wouldn't have found harmless error. So I think here, where it's fundamental error, and we don't have that issue of severance, that it's quite a different case. Also, moving on to the next question, I think that we can say the different variants of disorderly conduct are the same misdemeanor for purposes of Section 13-707B. And admittedly, the statute, it could be clearer. It's probably ambiguous. We need to look at legislative intent to get to that answer. But I think it's a little more complicated than just saying, well, are they the same? And that must mean exactly identical, which is how I read the defense argument. Really what we're asking is whether they're sufficiently the same for a purpose, because the word same is kind of a relative, comparative sort of analysis. So,
Where do you see the ambiguity?
well, the question is, of course, whether reasonable minds could read the statute multiple ways. And one way of reading it, perhaps, the defense argues, is that the elements need to be exactly the same or they're not the same. And our estimation, the other reasonable way you can read the statute and the way we think the legislature intended it is if the different acts belong in one code section and that code section has a single offense title and the body of that section refers to all these different variants as belonging to the same crime, that they are the same for purposes of sentence enhancement. And so I think the structure of the way disorderly conduct is set up gives us assurance that the legislature intended that. A completely independent basis that you could use to get to the same conclusion is the fact that disorderly conduct is a unitary offense. Really what we're looking at here is we're looking at multiple ways of committing the same act. Unitary offenses are considered one crime for a variety of reasons, including the jury unanimity, double jeopardy, multiplicitous charging, that sort of thing. And so it makes sense that if your crime is one crime for those purposes, it would be one crime for this purpose as well. And if you look at the Dixon case and the four factors there, it seems pretty clear to me that disorderly conduct would be unitary. You have everything being under the same title in the same code section. You have the different variants sharing a lot of things in common. They have the same victim. They have the same mens rea. They have the same result. The defense makes much of the fact that the different acts are different, one of them being inaction. I don't think there's much weight to that. I think, like kidnapping, where there's a variety of different ways you can commit a kidnapping, what we're really looking at is the result. And the result here is you're disturbing the peace and quiet of the victim, whether that's a person, family, or neighborhood. And then the last two factors are whether you could commit one of these and it would preclude commission of the other, which isn't the case here. And then whether it's possible to commit them all at the same time. So when you put all of that together, I think you arrive at the conclusion that disorderly conduct is unitary, and thus if you have a prior conviction of one variant and then you've convicted subsequently of a different variant, you would have the same misdemeanor for purpose of the enhancement statute. If the court doesn't have any further questions, we would request that it affirm the conviction here, but remand for resentencing. Thank you.
Thank you.
Good morning. I'm Bill Hughes with the Yavapai County Attorney's Office, and I represent the amicus curiae in this matter. And I'd like to thank the court for considering and listening to the opinions of the amicus curiae in this important case and allowing me to have an opportunity to argue the issues that are raised. The primary issue from amicus's standpoint that I believe this court needs to decide is, what is a felony? And I think it's useful when trying to decide what something is or isn't under the criminal code is to go to the definitions that the legislature has given us. In this particular case, the legislature in ARS 13105 has actually defined what a felony is. And it's a fundamental definition that looks not really at what the crime is, but it looks at what the sentence for that crime is. And as I'm sure the court is aware, a felony is defined under 13105 as any offense, and I'm going to paraphrase, any offense for which a sentence to the Department of Corrections is possible. A Class 6 felony, which is the next higher offense, and the appellant has conceded that, I would submit, that the next higher offense to a Class 1 misdemeanor is a Class 6 felony. A Class 6 felony under the Arizona Revised Statutes in Chapter 7 of Title 13 carries the possibility of imprisonment in the Arizona Department of Corrections. Therefore, under the definition of what a felony is, it is a felony because a sentence to the Department of Corrections is possible. I'd like, in the few minutes I have remaining, to address a few of the issues that were raised in the appellant's brief and also in the response to the amicus brief. Specifically, one of those dealt with an argument that because a judge gets to determine the existence of the prior, that has to somehow be an element of the crime, and therefore it cannot be a felony offense because a jury is not making that finding of an element. The appellant cites a case, and I would submit that their citation to that case is incorrect. That was the Romley versus Superior Court case. Romley does not say that a sentencing enhancement is the same thing as an element and has to be found by a jury. Romley dealt with an issue of an actual element of the offense of whether or not someone had a suspended license.
Well, let me ask you the same question I asked the state. Indulging in our big if of setting aside invited error, would you agree that it is error to treat the prior conviction here as an element of the offense?
Your Honor, I do agree with that. Again, I would agree that I believe it's invited error. I don't believe it's necessarily prejudicial, but I agree that it's not an element. This is equivalent to the situation in State versus in the Flood case, which was a case that was referred to in the Darrow opinion cited in the appellant's brief. Flood dealt with the situation. It was a unique version of the Ag DUI statute where a person becomes convicted of a misdemeanor DUI, and then the judge finds the existence of prior felonies, and the existence of those prior felonies then allows the judge to sentence the person as a Class 5 felon. And that is State Ex Rel Collins versus Udall. Flood was the real party in interest.
Those are prior felonies or prior DUIs?
Prior DUIs. And I apologize if I misspoke and said prior felonies. The judge finds the existence of the prior DUIs. In that case, they found that those were not an element because the person was convicted of the misdemeanor DUI statute, and there was a separate statute that then says if you commit the misdemeanor DUI and you have the two priors, then it becomes a Class 5 felony.
Is that still how third offense DUI works?
It is not. I apologize, Your Honor. The legislature has rewritten it, and so now it actually is an element of the offense to find the two priors. But at the time,
does Geschwin still apply to that scenario then?
It would now, yes, Your Honor, because the version that we have in effect now is the same as the issue in Geschwin. And actually, Flood specifically addressed Geschwin, I believe, in the opinion itself. And again, the Flood is 149, Arizona 199. It's a Supreme Court case from 1986. And so I wanted to address that particular misconception that was in appellate's brief. Another issue that appellant raised in...
So what you're saying is that in the Collins case, at one time we had a scenario where you could end up with a Class 5 felony by way of being charged with a misdemeanor, and then a judge finding prior misdemeanors and end up with a Class 5 felony conviction.
That's correct. I believe that's particularly analogous to the situation
Seems to be.
that's before this court today. In fact, I have the language written down somewhere from the Flood opinion, but they address that very particular situation. It talks about a person being convicted of the misdemeanor and then becoming sentenced for
But
the
by
Class
way of
5.
your answer to Judge Swan's question is these cases would suggest the proper procedure.
I would believe this case suggests the proper procedure. I submit that there was not fundamental error and not prejudicial error in this particular case, but in the future, it should be a jury determining the existence of the current disorderly conduct. If the prior one's going to come in, it should come in my opinion, as other act evidence or something that would have to be subject to a hearing by that trial court before it came before the jury. Another issue that was raised in the response to the amicus brief was the citation in the Dangerous Crimes Against Children statute. And there was a citation in there that talks about look to, and it's, I believe, subsection J of the Dangerous Crimes Against Children statute makes a reference to the Dangerous Crimes statute and also makes a reference to 13707 in determining priors. I submit to the court that's actually helpful to amicus's case and argument, and that's because the only priors that are relevant in the context of dangerous crimes against children are what are called predicate prior felonies. And so therefore, if it's a misdemeanor, you wouldn't even be looking at it because you can never use a misdemeanor to enhance a dangerous crime against children. The only way DCACs get enhanced is with a predicate prior. And a predicate prior, by its definition, and it's defined at the very end of the Dangerous Crimes Against Children statute, a predicate prior, one of the requirements is that it is a felony, and then it has to be a particular felony, a sex offense, another dangerous crime against children, child abuse, and I'm probably leaving one out. But not only does it have to be a felony, but it has to be a particular issue or a particular status offense.
I'm sorry, would you remind me again, what argument were you responding to with
That was an argument that was raised in the appellant's response to the amicus brief. And in that brief, they cited to the Dangerous Crimes Against Children statute, which cites 213707. And again, I would submit that I believe that the fact that the Dangerous Crimes Against Children statute recognizes that these are felony convictions is helpful to this court's in consideration of whether they are felony convictions. And again, goes back to the primary question. When trying to determine what a felony is, let's look at what the legislature has told us in the definition. I have about a minute left. I would yield that time back to Mr. Christ if he has any other questions. Otherwise, I'll sit down unless the court has questions for me. Thank you.
I have nothing more to add unless the court would have any questions.
No,
Thank you.
thank you.
With regard to the argument about the reading of subsection B, it couldn't be plainer on its face. There's no need to go any further into that review because it simply says stands convicted of a misdemeanor. And we know from looking at other statutes, and they are fully briefed in our briefing, that when the legislative branch wants to say committed, when they want to say something else, they say it. And convicted means convicted. And words have meaning in this case, and they mean what they say. With regard to the argument about no prejudice because the jury instead of a judge found this, I point to ARS 13-707 subsection 11, ARS 13-703 subsection N, ARS 13-707 subsection C, Arizona Rule of Evidence 404B, Arizona Rule of Criminal Procedure 19.1B1, and all Arizona court cases since 1996. The judge is meant to find prior convictions except for in those situations where it's actually an element of the crime, and that is not what we have here. We have 2 decades of jurisprudence saying that it was the judge to find the prior conviction, not the jury. And the reason for this, and I disagree with the Attorney General, this is the exact type of case that warrants reversal. We are not arguing State v. Burns as it's holding. We're not saying that it's holding is binding on this case. We recognize some of the differences, but the analysis in that case is applicable to this case, specifically that In Burns, again, they did not even hear about the exact same prior. They heard about a different prior. Here we have disorderly conduct and then a prior conviction for disorderly conduct. And what's interesting about what the Attorney General is saying about the jury acquitting on the aggravated assault is they did acquit on the aggravated assault. They didn't hear about a prior conviction for aggravated assault. They convicted on the disorderly conduct, which is what they heard about in terms of the prior conviction. With regard to the limiting
It
instruction.
wasn't like there wasn't, the trial wasn't devoid of evidence against your client. I mean, the conclusion that your client committed disorderly conduct was not a stretch, was it?
I disagree, and actually Burns goes into looking at the actual evidence, because here we had the only eyewitness to the event. There's only one eyewitness who testified. She had a story about being beat over the head repeatedly with a curtain rod, and we know the jury did not find that to be credible because they acquitted Mr. Gawley of aggravated assault. What they convicted him of was what he had previously been convicted of, but the only person who actually saw and witnessed the crime was not fully believed by the jury, and that is markedly different than State v. Burns, where the court then looked, when deciding the prejudice prong, they looked and decided there was ample evidence, including DNA evidence, against that particular defendant. Finally, with regard to the unitary, non-unitary offense, we don't believe that applies in this context. It doesn't make sense that someone would be punished for committing the same theft, having committed the same theft, any subsection, but wouldn't have an enhanced sentence for committing assault and then committing a different type of assault. It just simply doesn't apply here. Thank you.
Thank you very much. Counsel, thank you for your arguments. Both were done very well. We are going to take a brief recess so that we can let the parties for the next case come up, and we will take the matter under advisement and issue a ruling in due course. Thank you.